SJC-13467, Commonwealth v. Hairo, Baez.
Okay, why don't we just let Attorney Semmel get settled? All right.
Okay.
Attorney
All right.
Semmel.
Thank you. Good morning, Chief Justice Budd and justices of this court. I'm Joseph Simons, and I represent Hairo Baez, who is the appellant in this case. As you know from reading the filings and the record of this case, Mr. Baez had come over to the United States from the Dominican Republic as a 4-year-old with his mother. All he knew was living in the United States, but for visiting the Dominican Republic from time to time. During his high school years, he did get charged twice in the Peabody District Court, and on the advice of his court-appointed counsel, he ultimately pleaded guilty. Now, years after that, when he was about 24 years old, he went on a vacation to the Dominican Republic, planning to be there for about 2 weeks, comes back and realizes for the first time that those guilty pleas had the effect of not allowing him to come back.
So how long has he been in the DR now?
He's been in the Dominican Republic since 2011. So he's been forced to build a life in a place that he previously only knew from visiting and from before when he was 4 years old and below. He's, not that it's part of the record, he's got a couple of kids, he's got a wife, and he's tried to build a life for himself, but it took years before he could even gather some money together to hire me in order to go file a motion for new trial, which we did, I think, in 2020-ish or so. But
So are you saying that if he had not had an issue, had he not committed crimes and gone to the DR and then tried to come back, he would have been allowed back in?
Well, I don't know. I can't speculate. I mean, at a certain point, there might have been some sort of enforcement action because apparently he wasn't really able to be here legally. Right. So perhaps ICE would have decided to make some sort of enforcement action, even if he hadn't left.
But he came to the attention of people when he came back in.
That's true.
Yeah.
Yeah, that's accurate.
And can I ask the opposite question, which is that even if you prevail in this case,
yes,
is it certain that he'll be able to get back?
Not being an immigration lawyer, I don't know the answer for sure, but I have come to understand nothing is certain in immigration law.
The briefs are unclear, obviously, about the exact situation. An amicus brief, I think, is the one that's clearest on the idea that this is a discretionary determination with the consular office there, and one's criminal history is you have to disclose your criminal history.
Sure.
Do you know what he would, if he prevails here, do you know what he would have to disclose?
My understanding is that he would still have to disclose the nature of the charges that he faced, but if he were, let's say, acquitted or the cases were dismissed, then my understanding is at least he would have a much higher likelihood of coming in, whereas here, my understanding from him through his immigration counsel is that he would have a bar from coming back. Right now, he's just ineligible to come back.
But there's no reflection in the record that he has actually applied for a visa.
No, and I mean, I don't know how clear the record is in terms of his affidavit, but I know that he has had immigration counsel who has told him that he is not eligible to come back at where things stand right now. So,
and I'm sorry, you know the record better than I do. Is that in the record that some sort of affidavit of immigration counsel saying because of the pendency of these charges, Mr. Baez can't come into the United States?
my best memory of that is that there is, but it's not from immigration counsel, it's from Mr. Baez, citing that he spoke with immigration attorney Susan Church, who was his then attorney.
But nothing from Church herself?
I don't believe so.
Okay. Sorry, thank you.
Sure. But
Does he have a right to be tried by way of Zoom?
there hasn't been any sort of case law on that point, but I would argue that he does have a right to be tried. I mean, he has a right to a fair trial and he has a right to a speedy trial, both of which he is pursuing. I mean, he's even gone so far as to waive his right to be physically present. It's something that he's, given the circumstances, it's, I guess, the lesser of two evils, but it's something that would at least ensure that his right to a trial, a fair trial, speedy trial, I believe could be conducted and could be done under the circumstances under which I represented on the record in the district court, that I had had good communication with him.
How does he get a GPS when he's put on probation?
It's a good question.
What
I
if
don't,
he's found guilty and has to be imprisoned?
well, I guess that could come up in some cases. I would not expect it to come up in this case, given that he's already been, he completed a sentence that he previously served, and I would opine that a trial court judge likely wouldn't.
The problem is we're setting a rule for all cases, not your very, very, very unique case where he can't be punished further.
I understand that. Yeah, it's difficult. I suppose then a court could issue a warrant, and then that warrant would just exist in perpetuity until either he gets extradited back or until he illegally comes back.
Basically says to the government, heads I win, tails you lose.
Well, I think everybody.
If I'm found not guilty, great. If I'm found guilty,
I would argue that the government has resources to try to get somebody back if they wanted to extradite, that they could take steps which have not been taken in this case. I understand where you're coming from.
Don't you still have your right to pursue your speedy trial? You can try to, if they don't prosecute him after a certain point, you can move to dismiss as a speedy trial violation, can't you? Isn't that?
you have the due process prong of Rule 36.
Well, I suppose so. But I think just from my experience, most trial court judges, if a person can't come in person, they're just going to put a warrant out. And I guess my understanding may be wrong, but my understanding is with a warrant, that sort of tolls the speedy trial clock. If a client defaults, then there is no speedy trial clock ticking at that time until the warrant's removed.
Not if they know where he is and they can get him.
And the defendant files a motion saying my due process rights are being violated. I don't see how that time could be counted against the defendant.
Okay, well, if that's the case, I would ask that you make that clear in this opinion, because I think that there's other people in his position that this will apply to. And so if somebody can, as you suggest, further their speedy trial rights, even when they're not able to be here and a warrant is issued, as I expect would happen, that would be good to have some
It's not a
clarity on.
guarantee. Obviously, the judge could say, well, come on in and we'll start it back up.
Well, and that's a point I think that I want to make, and although it doesn't necessarily apply to Mr. Baez, I think as you're making rules for all courts, there are courts that require a defendant to come in person. I mean, there's so many variables. I was in Lawrence recently where I filed a motion, asked to be heard, and they basically said, well, you have to come in person to schedule this hearing. And I mean, there's just all sorts of times where I've seen judges say, no, we need to see your client here or we're not going to address anything.
I can't get him here. They won't give me a visa. I tried. By the way, the record doesn't indicate whether he tried to get a visa, does it?
I don't think he actually applied for a visa, bless you. I don't think he applied for the visa because his attorney at the time, his immigration attorney, had advised him that there was no point to doing so.
Defense lawyer would advise him to do that differently, possibly. If
Perhaps.
moving to, yeah.
Okay, I hear you. I understand. So be that as it may, I think that this specific case, there's no justice to be done. I mean, to Justice Gaziano's point about heads I win, tails you lose, everybody loses here. I mean, if the government here is pressing for a trial because they want justice, and they want justice for their victims, they want to seek a conviction, they're clearly not dismissing this case that's now close to 20 years old. They're also obfuscating that ability. I mean, we've got Mr. Baez who's willing to put himself before the court in the only way that he can.
They're worried that if this goes forward, there are going to be all kinds of issues with the jury trial. He can't get here. He's going by Zoom. He's the only one not in the room. He's disadvantaged. If there's any technological glitches, when the jury evaluates his credibility, it's going to have him just sitting there on a screen. I don't know. They may be saying to themselves, this could be a mess. We just don't want to do this.
I can understand that, but I think we can't just worry about what ifs. I mean, I've had times when I've been in trial. Last summer, I was in Bristol County, and we were supposed to be in court, and the recording system didn't work. I mean, there's technological glitches that happen. We had to take the whole day off after waiting for like 3 hours, hoping it was going to come back up.
Well,
to the Commonwealth.
Sorry, counsel. I think the issues go beyond technological glitches, which I agree, unfortunately, can come up in a lot of different cases. That it seems to me like there's a more fundamental issue here, which is that this is the unusual waiver of presence case where your client seems to want to be here, right? And so it's almost like the most compelling reason to allow the waiver of presence is also the involuntariness of his absence. And I think that was also part of the lower court's, the single justice's concern at least. So could you address that point, that even if we had a smooth trial, and even assuming that the trial, he was not unfairly treated at trial, that even after trial there could be an issue?
Sure. Well, I think that that's not unlike a client who might be in jail awaiting trial and they're on a bail they can't afford, and so they decide to plead guilty because they're offered a probationary sentence. You could argue, I guess, that that's not a completely voluntary waiver of rights when you're pleading guilty to something because it's going to get you out on the street sooner than if you were to press
But in
your
those
registration.
situations, we don't actually know, right? Here we have counsel standing in court saying, basically, my client wants to be here but can't be. We don't have we have whole plea colloquies to try and ensure that a plea is not like that, right?
There are. I would respectfully say that that happens a lot, though, unfortunately, especially with court-appointed clients. But be that as it may, we're not here for that. I think to your point, though, under the circumstances, it is a voluntary decision because it's either that or not come at all and just not.
Isn't that the essence of involuntariness on some level, though, that he doesn't have a choice, right?
I would argue he has a choice to not pursue his right to trial. I mean, he could have sought to do a plea, or he could have, I mean, there's other options. It's not just a Zoom trial or nothing. So I think of the options that he has, this is a decision that he's made with the advice of counsel. I have gone to court. I've represented what his request is. And at first, the trial court judge actually allowed it, by the way, which I thought was unusual, but the right thing to do, in my opinion, anyway. And then she later made a decision because of the trial court rules, but she encouraged us to come seek some relief from you all, hoping that we could get a little bit of clarity, I assume.
Did you find any cases anywhere like this where a client wants a Zoom trial because he can't get into the country, or any Zoom jury trial cases like this that we should look at?
I wasn't able to, no. I mean, there may be, I didn't find any. But if I could also, to your earlier point, just to, I talked about the technological issues, but also the Commonwealth had raised the issue about, well, my client would be on his own. There'd be no supervision as he would be in court. And I can understand that, but my point to that, my counterpoint would be, if a client is in court physically and they're doing something that would obstruct justice or doing something that's inappropriate in a courtroom setting, the trial judge always has the ability to have him ejected. That does happen sometimes on trials where a client is removed from the courtroom and the trial proceeds without that person. How easy would it be for a trial judge to just tell the clerk, press the button, and they're removed? So I think any concerns, any what-ifs can certainly be addressed, and we've had about 2, 3, 4 years of Zoom capabilities with these, pretrial hearings mostly, and they've gone, I would say, mostly smooth. I mean, you hear about things here and there, but for the most part, I think you don't want to throw away this opportunity just because there's been some bad behavior here or there.
But I think if the Commonwealth agreed, you'd be in a different position, right? So that's why I asked whether or not you had a right, whether your client has a right to this.
Yeah, I mean, yes, I would argue that he does. I would argue that he does by way of his constitutional rights to having a fair trial and a speedy trial. And again, I think both can be accomplished with the technology that we have available with Zoom. The Commonwealth's concern about these trial court rules not being followed, and that seems to be a big point of contention, like, oh, well, this Zoom trial is inconsistent with the trial court rules. I mean, if you look at Dorchester and Dedham, they're not doing Zoom at all, and that's in violation of the trial court rules that says compliance in election hearings are presumptively by Zoom. I mean, there's lots of courts that just aren't following them at all. And frankly, the rules allow for some discretion, because even if something's presumptive or not presumptive, anything that's in there pretty much is allowed to be modified by the trial court judge in a given circumstance. And as much as I know this case law will affect much more than Mr. Baez, I think the circumstances of this particular case and where he finds himself would further justice, not just for him, but also for the alleged victims and for the public, who also has a right or has an interest in seeing trials adjudicated fairly and promptly.
Could you?
I'm sorry. So your position is any client has a constitutional right to a remote trial?
If they, one, waive their appearance physically, and two, that's really the only way that you can get to trial, I guess.
Like
Under the-
even like, even like the Whitey Bulger of the district court, someone that's been a fugitive can say, all right, I'll beam in now?
Well, I guess that's, I mean, I don't know. I mean, Whitey Bulger was never outside of the country that I know of, that, you know, outside of the jurisdiction. I think in that case, the federal government certainly could have brought him in. And
No, but
it's a
what you're saying is, you know, if someone from parts unknown can just say, I want my Zoom trial.
I think if they're in a position where they can't come here legally, then yes. If they
Or
waive their
if they-
presence and they can't come here legally, I think under those two circumstances, yes.
All right, you've added a third element, that they can't come here legally.
They can't come here legally. The only way that he could come here for a fair trial, he'd be violating federal law and be charged potentially for a new crime. So, all right, with that, if I don't have any other questions, I thank you all for your time and consideration.
Thank you. Now it's time for Attorney Semmel. Sorry about that earlier.
Good morning, or good afternoon. I think we're on the cusp. May it please the court, I'm Catherine Semmel for the Commonwealth. If I could just first answer Justice Wendland's question, which I think defense counsel answered the same, but just to be clear, only the defendant filed an affidavit about his inability to come back into the United States, and he did so only in conjunction with a single justice proceeding. It's dated, in fact, about a week after the ruling from the trial court. It was never presented at the trial court. It was very iffy at the trial court. It was really defense counsel saying, it's my understanding he's been deported, he can't come back into the United States. So there's no real factual foundation.
The government dispute that?
I think that
I mean, it is, after all, the federal government's rule.
it is unclear, and I think as was pointed out, it's probably the amicus brief that I don't have a great deal of immigration knowledge myself, but even the amicus brief said only that it's possible that he wouldn't be able to get a visa due to the pending charges in this case. So it's entirely unclear. And certainly if things proceeded at the trial court after this decision where speedy trial, due process was brought up, this would have to be fully litigated and determine exactly what was happening, whether a visa had been applied for, and whether, in fact, the defendant was unable to come back into the United States. But basically what happened at the trial court was that the judge reconsidered her ruling allowing the Zoom trial on the basis of the standing order, which the standing order in effect in the district court.
Seems a little artificial if are we really, are the rules really governing here, or is this sort of a bigger picture issue? You know, it seems like the rules could accommodate this, right?
I think it's possible. I think it's possible there's a residual kind of clause that says that any event that...
You'd agreed and they'd agreed and both thought this was in the client's interest. It would be a rule violation to have this done by Zoom. I understand why you may not want to agree to this.
Right.
I get it, but the rule seems like it's kind of
personally,
an issue.
Personally, I think it's possible that it could be in the judge's discretion if both parties agreed and the court felt that it was appropriate and all the safeguards were in place, that if everything came together, I don't personally think it would be an abuse of discretion for the judge to determine that a remote trial could be held or that the defendant could be remote. But I think that definitely over the Commonwealth's objection, it would be an abuse of discretion to allow it. And it was not an abuse of discretion to deny it in this case.
Can I ask, so if he couldn't get a visa and he tried, and he's trying to clear his name, but he can't do it, does he have a right to a Zoom trial over your objection? And if not, why?
I don't believe he does. I mean that...
He just can't vindicate, he can't, I mean, I understand maybe he hasn't done enough here, but he can't exonerate himself if he can't get into the country, if you won't let him do a Zoom trial. I'm just trying to figure out, does he have a right to a Zoom trial? You know, he's fully informed, the judge gives a detailed colloquy, you know, you're not going to be in the room, you're at a disadvantage. And he goes, Judge, I I want to clear my name, and they won't let me into the country. Does he have a right to Zoom trial in that context?
I don't think he has, and I don't think the defense has pointed,
Not.
because you have a right to be present, clearly. The defendant has a right to be present at his trial. But I don't think he has a right to dictate for the court that he wants to be present in this particular way that is not the way trials are conducted in the Commonwealth.
The federal government won't let him in. If, again, I'm not saying that's established here, but if we're going to have a case where the federal government's not going to let them in, and I'm trying to understand it. I get why you don't want to do this. I'm just trying to understand whether he has a right to try to exonerate himself.
Yeah, I think that his remedy is to file a motion to dismiss the charges, which I realize is not the exact same thing as going to trial and being acquitted. But I think that that is his remedy to do that, and that
On the basis of?
on the basis of, speedy trial, due process, all the things that were articulated by Justice Lowy, all the things that were not raised yet in this case, have not been, argued at the trial court. But, this decision is the case doesn't end here. If the court rules in the Commonwealth's favor, then that just means that there's no Zoom trial.
Why, I know Justice Kafka understands your reasoning. Can you explain it to me? Why is the Commonwealth not agreeing, given that the defendant has already served any possible time?
Yes, because that would be another important consideration, absolutely, an inability to impose a sentence. But there are other reasons. First of all, it sets a precedent for other cases where it's merely perhaps inconvenient for a defendant to come. Other cases where an individual is has other obstacles to coming. But as to the trial itself, there's a difference, and Justice Kafka articulated some of these in Vasquez-Diaz. There's a difference in testifying via Zoom, and the defendant in this case could clearly testify in this case if he wanted to.
Go against him. The thing that goes for you is if he gets convicted, you can't do anything about it because he's out of your jurisdiction unless you.
Well, and I'd add that not only can you not do anything because it's out of your jurisdiction, but because as a matter of law, you can't impose a further sentence.
Right.
Yes. So in this,
So if this decision were narrowly tailored to Mr. Baez, the government would be fine because there would be no precedent?
no, because we do think that the Commonwealth should have a say in how these trials are conducted. If the defendant is just requesting that the traditional trial change.
How did the pretrial motions or pretrial activity get resolved? Were they by Zoom?
I believe Mr. Baez was by Zoom or was excused. Okay. I don't recall precisely, but yes. Yeah. And we have agreed to that in certain, we didn't oppose when he filed the motion for new trial, and that was resolved, but it wasn't an evidentiary matter.
So it's only when the defendant wants to participate by Zoom in a trial as to which there's no further punishment possible that the government is objecting.
We're objecting to the procedure.
So in effect, what the government is doing is keeping Mr. Baez out of the country.
We don't know if that's the case. We don't know if he actually can't come
Assuming
back.
that there was an affidavit from Attorney Church that the laws, immigration law, is such that if he has pending charges, he can't come into this country. Assuming that record was better, as Justice Kafka was suggesting.
That might be the result here. That might be the result.
Right, because there's no further punishment available at the state level. The only punishment that Mr. Baez is suffering is his inability to come back to a country where he grew up.
Well,
far as we
there
know.
would still be the conviction, right? There may not be any subsequent punishment, but he could be convicted,
Yes.
right?
He could certainly be convicted again.
And could he be resentenced again?
No.
No.
I don't believe so. I don't believe so, Your Honor. but of course, you know, that is not the typical case, but is this case? It's correct. I really think that it is going to be years before we flesh out in the courts all the ways in which the defendant can challenge a conviction that's done in any way remotely. And I think we saw it in Commonwealth versus Curran, where a bench trial took place. The defendant didn't object to being remote, and there was an appeal with a litany of claims in that case, which were rejected, but which were considered, obviously, as to presence, as to ineffective assistance. You know, there are definitely differences in conducting important witnesses, particularly, or defendants, you know, by Zoom. And this case is particularly problematic because he's not in, for instance, you know, ICE custody in New Hampshire. He could be, you know, he's sitting in a Starbucks somewhere. I mean, there's no control over the way it's going to occur. This is a technological point. You know, there's no control over the setup and his access and all of these things. There's no oversight of it at all. And I think that's a problem, but it's also just a problem having witnesses appear by Zoom, and it changes the character of the proceeding, where the defendant doesn't even have to physically show up to trial.
Remind me again, in Curran, was it the government that wanted to go forward by Zoom?
I think it was agreed. There was no objection brought. I don't think it was spelled out in the decision, but I know that there was no objection.
Can we return to the topic that we were discussing earlier with your fellow counsel? Can you talk about the practicalities of what's going to occur here? Let's say, hypothetically, that the single justice were affirmed and then things move forward. What is going to happen next?
I think the ball is probably in the defense court as to what they're going to do and what action they're going to take with regard to.
Would you have a Rule 36 issue, defense?
Possibly. I mean, none of this has been fleshed out. None of it was raised. You know, there are ways for the case to conclude, and there are claims that can be brought by the defense. None of them have been brought yet, and I think Justice Lowy made that clear in his decision, that none of those were.
Commonwealth hasn't waived any argument that the defendant should be tried in absentia.
Right. We haven't ever raised that, and we haven't waived it.
Mm-hmm.
Well, can I be a little more specific then? I appreciate everything you just said, which is helpful, but more specifically, let's take as a given that the affidavit is correct, which simply says he cannot be here. Let's just assume that that's correct. And so he cannot be here. And let's also assume he does not obviously want to plea to these charges, because the whole point of why, yeah, you understand. I think that could be potentially taken as a given. So given at least those parameters, what do you think would, as a practical matter, occur? Will he be defaulted?
I think he hasn't been defaulted yet. I mean, the judge, there was some question at I believe the last hearing about entering a default, and defense counsel asked for there not to be a default entered, and I believe the judge agreed with that. And for potential immigration purposes, that it would just make it harder for him to get back in. There's no plan to have a default entered at the moment. I don't know precisely what steps they'll take at the trial court, but I don't believe there's a default right now.
What is the Commonwealth's interest in maintaining this criminal prosecution after, if we were to affirm the single justice and then we send it back and he's not here and no one wants to default, the Commonwealth doesn't seem to even be asking to default him. You know, can you talk about the interest at that point for the Commonwealth?
If you affirm?
If we affirmed the single justice, so that means that it's sent back, it's essentially status quo, he can't have a trial because he can't get here, and you've successfully convinced the court that we can't force the trial court to have him appear by Zoom. No one seems to be requesting that he be defaulted. It's just gonna hang there. Does the government have an interest in continuing the case at that point?
I think we have an interest in resolving the case if the defendant can be present. We have miraculously, our witnesses in this case, in two very old cases, we had our witnesses available. But I think our position is that we do not want to have a remote trial. And
Always dismiss it without prejudice, let them come in, and then take the charges out again and have your trial.
that's one possibility. It's also a possibility that the case will be dismissed by some action that the defendant takes. You know, and you know, that's a choice that we've made in proceeding with this case, and we think it's important. We don't think that a Zoom trial is appropriate in these circumstances.